So thank you very much. My name's Ethan Litwin. It's a pleasure to be here. Thank you to Willie and the IDA for inviting me to speak. I thought I'd take a couple minutes up front to tell you a little bit about what I do, and that'll put everything into context. So I'm an antitrust lawyer. In Europe, call it competition law. It's virtually the same thing. It comes from the same premise, which is when you create wealth, what happens to it? And typically you think a company creates wealth, a chunk of it, about 60% goes to labor, the rest goes to capital. There's of course cost of capital, so some of that goes to the banks and financing and shareholders. But increasingly, particularly in your space, you have third-party companies coming in and saying, you're using our equipment. You may have bought it, you may own it, but we created it, and when you create wealth, we're gonna take a significant chunk of that. And increasingly, that's affecting farmers, that's affecting distributors, truckers, and a whole host of folks across the economy. And that's what we're here to talk about solving, and what Willie's been working on for a very long time. As a lawyer, I have many tools in my toolbox to help clients solve problems, because that's what we do. If your lawyer isn't a problem solver, get a new lawyer. The first and best means of solving a problem is negotiation. And I'll talk a little bit about what negotiation can happen at the end of the presentation. But unfortunately, companies like John Deere, technology companies like Apple and Google are not willing to negotiate anymore. They're imposing terms on take it or leave it basis. And that's leaving everybody in a tough position, because increasingly a large share of the dollars, euros that you're making are going to these companies. And that requires more aggressive tools. So of course, the ultimate tool is litigation. And as Willie mentioned, there's some really good progress being made in the courts these days. But that's not the only way of solving a problem, and perhaps this problem, being so big and so fundamental, can't be solved entirely in the courts. So you have regulation. We call it government enforcement. Our antitrust enforcers don't like being called regulators, even though they do, in fact, regulate the economy. Here you have member state competition enforcers. You've got DG Comp in Brussels. There's, in the United States, we have the FTC, the Antitrust Division of the Department of Justice, and various attorney generals, all of which can be brought together to help solve this problem in a systematic way. And then finally, you have legislation, because in some areas, these problems are gonna run so deep that we need to change our laws. And we'll look at all of that today. So what are the challenges we face? Legally speaking, under US law, monopolies are not illegal. And that is the #1 challenge that we face. Europe has a much different tradition. In competition law, there's a concept of market dominance and abuse of a dominant position that gives a lot more flexibility to regulators in Europe to tackle these problems. But in the United States, just because you have 90%, 95%, or 100% of the market, so long as that was achieved through lawful competition means, you're allowed a wide latitude of business strategies to exploit monopoly power in the United States. Second is intellectual property, and that's where the rubber hits the road with right to repair. As vehicles in particular become computers on wheels, companies are using the same tools that software and hardware companies in Silicon Valley used to create walled gardens that are preventing right of repair and extraction of monopoly rents. And finally, despite the gains that we've made in the courts, we still deal with some degree of judicial conservatism, where a single judge who's a generalist is not always willing to break apart entire sectors of the economy and reorder how they work. So while on the merits, we may get good verdicts and we may get great damage awards, the going forward relief, the structural relief that will change our economy for the better, isn't always something that can be achieved in the courts. And that's why you need some combination of regulatory action and particularly legislative change. And then finally, and then we'll get to the slides very quickly, is why now? Why is this the right moment? Well, we have some unique momentum. Starting under the Biden administration, the ship of policy began to turn for the first time in 45 years, where we woke up as a society, both on the right and the left, and said, we have dominant entities and ossified industries and oligopolies throughout our economy that are taking a disproportionate amount of every dollar earned. And that's not fair, and that's not competition, and that does not bode well for the future, because every economist will tell you that oligopolies and monopolies tamp down on innovation. They seek to preserve what they have rather than create for the future, because that creates uncertainty. In the courts, we've had remarkable success against John Deere, Apple, Google, and other large companies. And there's a changing perception that makes this the right time to move forward. So I'll skip through these slides pretty quickly so we can get to more of a discussion. What are the principles of right to repair? What do we mean? And essentially what we mean is, you bought it, you own it, you should be allowed to repair it the way you want, to hire the people you want to repair it, and you shouldn't be overly reliant on OEM parts in the aftermarket when you do so. There shouldn't be essentially a tied obligation to use parts by the original equipment manufacturer to repair your vehicle if cheaper, equally good parts exist from aftermarket suppliers. And where you do need code from a manufacturer or a specialized part from a manufacturer, that should be provided on fair and reasonable pricing terms, what we call FRAND. So depending on what sector of the industry you're in, there are different issues that affect right to repair, but that's essentially what we're talking about. Why does it matter? Again, we've talked about higher costs. More money is going to OEMs in the repair sector. It creates delays, it creates downtime. That hurts everybody in the marketplace, but particularly, you think about farmers who have limited time to get seed in the ground. If their tractors are sitting idle because the OEM can't get around to repairing it, when a third-party repair shop could come out to the field, fix it on site, and get that tractor up and running in hours, that affects yield, that affects the amount of food that's going into the economy. It raises food prices, it hurts the farmer in his pocketbook. There's no winner there except for the OEM. And of course, you have reduced competition. And reduced competition in this sector means more monopoly profits going to the OEM. At the federal level in the United States, the FIX report, which was a very clever name that the FTC came up with, really brought right to repair to the general perception of the American people. And the FTC focused on a few things. Parts pairing, VIN burning, for those who know what that is, it's where a part can only be used on a certain vehicle if it's coded correctly. Software locks, and denial of important documentation. The FTC specifically warned companies about tying their warranties to repair issues. So that if you use a third-party part, if you directly fix your vehicle or your electronic device directly, that voids the warranty. Unless there is a real tangible reason to do it, because it's somehow going to affect the performance of that vehicle or electronic device, warranty tying is illegal. The FTC then began to act on their policy statement. They sued Harley-Davidson. They opened up many sub-investigations, many of which are still ongoing. And more importantly, earlier this year, they sued John Deere. It's a companion case to a class action that's already pending in the Northern District of Illinois outside of Chicago. And they've had very good success in that case. It's a broad, wide-ranging case, but essentially what the FTC is trying to do is trying to get farmers direct access to the tools and data that they need to repair their tractors themselves or to have a third-party repair shop do it, where they need parts or particularly data from John Deere, that must be licensed on fair and reasonable terms, and ultimately to stop steering all repairs to John Deere dealerships. There's been good success in the case. The John Deere moved for judgment on the pleadings, which is an early motion to get rid of the case. In the class case, it got denied in November 2023. So a few months ago, the court denied a motion to dismiss the FTC case as well. The court also recently ordered production of John Deere's profitability data. So we'll begin to see what John Deere's practices have resulted in terms of their own corporate profitability. And if you follow their stock prices, you have a pretty good sense of what that is. One interesting development is John Deere, and I'm sure Willie will talk about this later, voluntarily entered into a memorandum of understanding that supposedly has opened up their repair platform. As with every voluntary agreement entered into by a monopolist, we have grave concerns about how useful it'll be in practice, but we'll get greater clarity on that, but it has been widely criticized.
By me.
Yeah. So we've had some good legislative momentum. There have been a number of laws recently passed on right of repair, but as you'll see on this slide, they've almost overwhelmingly concerned electronic devices. They're about repairs of iPhones. They're not about what everybody in this room does. Although there have been some state efforts to pass agricultural right to repair bills, so which can have a broad range of effect on commercial vehicles. They've all failed to get through the original legislative section, and at least the most recent information about the Texas bill is that it's dead and buried. But we do have hope that at least some of these bills will pass and join Colorado as the first state to pass an agricultural right of repair bill. There's the Federal Repair Act. Broadly speaking, this is a bill designed to ensure access to codes, to calibration tools, to sufficient manuals and information to allow for third-party repair. And the ultimate goal is to provide competition in aftermarket repairs. And it faces a tough road ahead, but there's a lot of bipartisan support behind it. So this is one of the few bills where we see Republicans and Democrats actively working together. And there is some hope that it will pass, although not any time in the near future. Unsurprisingly, the OEMs have fought back. They've done it in several different ways. One is they say that opening up their proprietary computer systems will lead to cybersecurity concerns, that terrorists will somehow change the onboard navigation tools and cause crashes, to all kinds of horror stories that have largely proven not to be true. There's been significant advancement here so that low radius connectivity is increasingly being allowed. It's supported by the federal government, and that's a big win. Voluntary agreements like the John Deere MOU are going to become more common. It's just to present another litigation hurdle for us to get over in the courts. Vehicle manufacturers are increasingly creating roadblocks through telematics. They are relying on IP protection to create walls that owners can't get around. This is an increasing battle for us in the courts. And then finally, the OEMs have come up with a bevy of economic, safety, environmental concerns, which are all largely bogus. And in fact, the EPA earlier this year said, yes, competition in aftermarkets is actually good for emission control, not leaving it in the hands of a monopolist. So at least on the environmental side, we seem to have pushed back effectively, but there's a way to go on these arguments as well. So what can you do now? The first is, as always, document everything. If your costs are going up, document why. Figure out where your data is and how you would prove your case if you needed to do so. Audit your tools. Ensure that you have the right diagnostic tools in your disposal. If not, figure out what you're missing and then figure out how to get it. Most notably, and I have a slide on this next, is you can increase your negotiation with OEMs. All OEMs are concerned about right to repair and monopolization suits. So there may be an opportunity at the negotiation table to get more than you have historically. At the very worst, you can ask for things and get denied, and that creates a take it or leave it record that can be then used to break contracts and show that the OEM is acting monopolistically. You can leverage certain state laws. That is only going to increase in the future. And of course, it's always important to train your team about what they can do in independent repair and what they can't. So you don't fall afoul of manufacturer rules that can get you in legal trouble. And you certainly don't want to cut your nose to spite your face. In terms of a negotiation wish list, you want to ask for complete diagnostic access. The answer is likely to be no, but you again want to create that record that they're telling you no. That's a really powerful tool to have later on in the event of an investigation by a regulator or in the event of a litigation. You want a guarantee that parts are going to be there for any vehicle that you buy. You want data portability rights so that you can take the data that you have created and give it to a third-party vendor. You want software access. Again, that's increasingly hard. You want to fight back against OEM VIN burning and other techniques that they use to essentially create certain parts that can only be used for a vehicle. And then continuity protection. It's important, of course, if all of these restrictions are going to be put in place, that the manufacturer is going to be there 5, 10, 15, 20 years down the line. and that you're not going to be stuck with a vehicle that can't be repaired. Again, a 90-day action plan on what you can do right now to put yourself in the best position to evaluate whether or not you have a claim, whether you can want to approach enforcers and regulators across the globe and start enforcing your rights. This presentation is, I can email it to you, just let me know and give me your card and I'll send it off to you. I'll send one off to the IDA so that they can distribute it as well. But I don't want to take any more time and give it back to Willie.
Thanks. I just wanted to share a little bit of the context. First of all, nixing the fix. I was there during the actual presentation and the nixing the fix, and one of my friends was the representative for the Electronics Association, and at the end of the whole presentation, the whole hearing, et cetera, he came over to me and whispered in my ear, menacingly, I might add, "See you in court, we're gonna fight this hard." So it's just kind of a sense of it. Also too, I was in Colorado when the final vote that needed to happen to get the ag right to repair done, and it was a 7.5-hour hearing, and I was the last person to present. And it felt a little bit like, for some of us that are old enough in the room, Clockwork Orange, when the punishment for the criminals was that they had to watch over and over their crimes. We watched every employee of the local dealers from John Deere testify how this would be horrible for them. Just some of the fun history, and I was just realizing is I think I've been to every one of those things that were there, so it's kind of fun. So what we want to do now with you and IDA is we want to shift the conversation a bit from information to action. Given the success that we've had with the multi-district litigation, I'm going to correct my lawyer friend. It's not a class action suit yet. It's a multi-district litigation.
No, it is a class.
Has it been certified?
It hasn't been certified, but it's still filed as a class action.
Filed as a class, okay. That's us arguing those finer points on it. So with the success of the multi-district litigation, with the success likely to happen with Federal Trade Commission, we're really going to start a conversation about what does a win look like? What does it really look like if in our marketplace we have right to repair and that we have access to the tools, that VIN burning, restrictive VIN burning or parts pairing is not practiced. So for us, that's a very important question. With IDA, we have talked with senior leadership at IDA. We are going to proceed with a third lawsuit against John Deere, where what we do is we're going to be representing the aftermarket parts manufacturers and distributors in the case where you are getting locked out of the aftermarket. So we're going to do some work over the next year. We're going to be knocking on people's doors and asking questions. I think the first thing that people in this room are probably going to worry about is, wait a minute, is somebody going to use my name in this kind of litigation? The answer is not unless you let us do that. We will need a name. So we're going to look for someone who's, as someone said earlier, who's really pissed off about right to repair, who's willing to stand up and say, you know, I think I can be the class representative for this case. So we're going to go looking for that. We're going to design the legal case in a way that represents and speaks to specifically the aftermarket with regards to your industry, mostly diesel engines, et cetera. And there's several ways that we can do it. I also think that to be respectful of the entire organization, we are also going to take a look at other venues outside the US. I know, for example, in Canada, there's some work being done to present to the Competition Committee or Competition Bureau, thank you, in Canada, abuse of, what's it called? The abuse of? Dominant position. That one's almost done. It's a bit of a hiccup on presenting it, but we're going to move forward with it. So our strategy on right to repair is basically an all of the above. We're going to do legislation, we're going to do regulation, we're going to continue to do judicial. We're going to add some new judicial, but we're also going to go international. So we're asking for your support in this particular effort. And quite frankly, we've gotten great support from the board and members of IDA, and so we want to go forward with it diligently so that when we're in San Diego, we will have some significant reports that we can provide to you and to the association on what we will be doing on your behalf. And I think at this point is a really good time to take any questions. Are there some out in the room, questions that people might have about moving forward on this particular topic? And we've got a mic back there if you want to use it. Yeah. Oh, no, just stretching, not a hand. Okay. It's all right. I'm kind of excited to go forward here. Oh, thank you.
Thank you, guys. This is a very complicated one. I've been on both sides of this equation when it comes to being a contractor, being a dealer for equipment, heavy equipment, and I understand the problem here as to someone monopolizing the repair of a piece of equipment, or whether it's farming or construction. I think one of the challenges that I see from a dealership perspective is just the cost of the tooling to get into those computer systems is very, very expensive. And for an independent shop to go out and purchase that tooling for a one-off for repairs, it's not plausible. Beyond that, it's the training that's required for the technicians to properly analyze it, what their information they're getting from the tooling. So I think, I can fully support what you're trying to do here. I think it's important that we have independence to have the ability to take on repairs for different various manufacturers, but I believe that there is some challenges here as to really how it's going to happen, like these repair shops are going to exist.
Hold on, we're both going to answer you on that one. Two things. Number one, John Deere announced 2 months ago a new software program. Their old software program, Customer Service Advisor, they admitted didn't work, even though it was part of their original MOU. The price tag on that was about $5,000. They've brought the price of their new product down to $195 per year. So big change there, so a big win in my mind. Unfortunately, the software is glitchy. They released it a little too early. And then the other one about knowledge and training, I will guarantee you that when my grandfather started introducing tractors on the farm that were replacing horses, none of those farmers knew about compression ratios, right? They learned. They're smart, capable people. They have skill sets on repair that are huge. And most of the independent repairs, certainly in the agricultural world, grew up on a farm. So yes, it's complicated. Yes, it's going to take some learning, but even I have learned how to use, various software programs. Sometimes I go to my grandchildren and ask, but we have learned on those processes. I think what you're saying, what I hear you saying, by the way, is that the monopolistic OEMs have made it very difficult to get access to the tools so that we can do it. So I want to stop that particular process so we can move forward, but I'm going to give the mic to Ethan.
So another facet of this is that there are many facets around these monopolistic practices. We can't look solely at the cost of the tool. The fact that there's no competition to create the tool is part of the problem. And stepping back from that there is no competition to create the part that requires the tool is part of the problem. And the fact that there's limited financing to provide for repair contracts from third-party vendors to fix the vehicles, that's part of the problem. So the challenge here to get long-standing, effective relief is going to require more than just a lawsuit, or 2 lawsuits, or 5 lawsuits, or 10 lawsuits. It has to happen in the courts, in the state legislatures, in the agencies. So that's part of what we'll be exploring with IDA, is how to affect broad change, working with partners in other sectors of the economy, maybe your friend from the electronics world. As you can see on the slide, I represent LKQ. They're a large distributor of aftermarket auto parts. They have a vested interest in this. They were a major contributor to the Nix to Fix investigation. So there are lots of ways to build alliances to help affect change in secondary ways around litigation.
And I think I particularly love your question, and I love the kind of thought that's going on of, wait, here's the environment now. What needs to change in our environment so that we do have a fully competitive marketplace, and not what I call a free marketplace where the monopolists are free to do whatever they want. Please, you get another question here.
Yeah, just wondering, is this a global phenomenon where OEMs are cornering this around the world, or is it particularly just to North America where they're not allowing it?
It's clearly global. Australia's Competition Bureau has been acting. India has been acting on right to repair legislation also. And I know Canada has done some very good work on interoperability. I mean, the landscape is really quite breathtaking in terms of how this kind of electronic control does monopolize, and how creative these companies have been to leverage the value of that. I'm going to pass it to you.
Yeah, it's been largely through intellectual property law. I mean, that's been the driving force. 35, 40 years ago, there were multiple lawsuits against Kodak and Xerox for monopolizing the aftermarket repairs of copiers and printers. And at least then, if you bought a Kodak or Xerox machine, you had to buy their ink, you had to buy their drums, you had to buy their parts. And the court said, yeah, you can't monopolize the aftermarkets that way. And then slowly, as the rise of the computer age happened, copyright law started creating barriers to repair. And the agencies and the courts were slow to adapt to that because they were very deferential to IP rights. and the pendulum is now swinging back. So there's a lot of momentum here.
Just a bit of history. It's a little bit ironic in my mind that much of the electronic control for these vehicles was really instituted because of emission controls. And so the Tier 4 engines, require computerized control in order to meet the emissions. And I've had long, difficult conversations with EPA staff, particularly on the non-road equipment. And fundamentally, they acquiesced to industry, knowing that there is statute that says any and all, quote, any and all information provided to an authorized dealer should be provided to the owner and independents. Their logic behind it was that they didn't have a control system, EPA didn't have a control system on non-road vehicles in order to test emissions. So they were gonna defer to the companies to do it. The first time I heard the phrase regulatory capture was in a meeting in Washington, D.C., and I had been fighting with the EPA guys for 2 years at that point. And when the staffer said, "Oh, you're just experiencing regulatory capture," John Deere, et cetera, they just go in and talk to those guys all the time and tell them stories, to be polite, about why the statute shouldn't be followed. So we're also gonna attack that particular process of regulatory capture. Any other questions out there? Yes, thank you.
Is the proposed case going to be, or is the proposal here for the IDA to be a plaintiff, or is it for an individual company or an individual?
So I think that's going to be an evolving analysis. The IDA is our nominal plaintiff. They have associational standing based on the interests of everybody in this room, or at least I assume everybody in this room, to challenge things. And the relief that they're allowed to seek is equitable in nature. So it's injunctive relief to provide forward-looking structural relief that prevents an OEM from taking anti-competitive actions in the future, and declaratory relief, declaring that the court would essentially issue a binding statement saying that the defendant, John Deere, or maybe others, have engaged in monopolistic practices. Based on that declaration, members of the IDA and others would have standing to go in and sue very quickly for monetary relief because liability would already be established and the defendant would be collaterally estopped from challenging liability in that lawsuit. We may, depending on how the case develops, look to bring a companion class action so that we can seek monetary damages at the same time, or an individual suit if there's a large enough plaintiff who wants to proceed individually. This is very early stages, but that's how we're planning on proceeding.
Any more in the room? No, Bruno's coming up here to kick us off. All right. Thank you, everybody. By the way, we are going to be tomorrow, we're going to be in a booth number 34, which is just out the door to the left. Come talk to us, bring your questions, talk amongst yourselves tonight. Tell us all the reasons why you think we're stupid, why it's wrong, why it's bad, or if it's good, that's fine, come and tell us too. But please, participate with us. This is going to be a fun couple of years working with you guys.
Yeah, and more importantly, we want to hear your stories. We want to hear how you are affected and what change would be meaningful to you, because that's how we put together a great case that provides meaningful relief for everybody. Thank you.